Good afternoon. My name is Aisyah Binti Ezam with the matrix number A168717, and I'm from Firm 7. And today I'll be presenting the case of Dato' S. Nala Kerupan and others, and Dato' Sri Anwar Ibrahim and other appeals 2015 that was held in the Court of Appeal Putrajaya. So in this case, the respondents had filed a defamation suit in the High Court against all three appellants based on an article published in Utusan Melayu, imputing that the respondent was a bisexual and was unfit to be the leader of the opposition in Malaysia. All the appellants had relied on the following facts: that the respondent was previously convicted on 4 charges of corrupt practices, and also made a reference to the judgment of the Federal Court in 2004 against a conviction of sodomy offences, as there was evidence to show that he was involved in homosexual activities. So in the instant appeals, the counsels for the appellant argued that a previous criminal judgment was relevant under sections 52 and 55 of the Evidence Act 1950 to show the respondent's bad character, so as to adversely impact his claim that for the damages in the defamation suit. So in this case, there are 2 issues. Firstly, whether the appellants can rely upon sections 52 and 55 of the Evidence Act to refer to the respondent's criminal conviction as evidence of bad character. And secondly, is whether sections 52 and 55 of the Evidence Act only allowed evidence of general reputation and general disposition to prove bad or good character, and not evidence of particular acts. So in this case, the learned counsel for the appellant has submitted that the previous criminal judgment was relevant under sections 52 and 55 to show the respondent's bad character. And the counsels also submitted that the remark by the Federal Court in 2004 is not an obiter, but it is an opinion based on evidence. And they also raised provision of section 53 and 54 of the Act to support the argument. The counsels for the respondent, on the other hand, submitted that the Judicial Commissioner of the High Court was erred in finding that previous criminal conviction of the respondent and pronouncement made by the Federal Court were relevant under sections 55. And furthermore, criminal judgment was inapplicable to the instant civil proceedings. So firstly, the court held that sections 53 and 54 was only applicable to criminal proceedings. Hence, the learned counsel's reliance upon section 54 was misplaced. And furthermore, in civil proceedings, only sections 52 and 55 of the Evidence Act were the relevant provisions. So pertaining to these 2 provisions, conviction for a criminal offense was not relevant as evidence of bad character. So the explanation to section 55 made it very clear that only evidence of general reputation and general disposition was admissible to prove bad or good character, and it could not be proved by a particular act. So in this regard, the court held that the Judicial Commissioner had erred in concluding that the defendant was relied on general reputation and disposition. Furthermore, the Court of Appeal also held that the appellant's reliance on the conviction of the respondent's second sodomy case and the respondent's act of homosexual activities in the first sodomy case, based on the remark by the Federal Court, is in fact relying on particular act to show his general reputation and disposition. So according to the Court of Appeal, this reliance was incorrect and was not permitted in the Federal Court case. It's not permitted by virtue of the explanation to section 55 of the Evidence Act. On the other hand, the remark made in the Federal Court case involving the respondent was based on inadmissible evidence, and it would remain as a personal opinion of the learned judge. Thus, such remark as evidence of fact would not have any probative value. With that, that's only from me. Thank you.